Good morning to all the participants on day 4 the Faculty Development Program. I am Manish Pratap Singh, Assistant Professor at the School of Law and Legal
Morning
Affairs,
to the participant
Noida International
program.
University.
I am
And
Manish
it
Pratap
is my
Singh,
great
Assistant
privilege to
Professor
welcome
at
you
the
all
School of
today.
Law and Legal Affairs to welcome you all
It is
today.
a matter of immense
It is a
honor
matter of
and privilege
immense
for us
honor
to
and
have with
privilege
us
for
this
us
morning
to have with us
Professor
this
Dr.
morning
Upendra Baxi
Professor
sir.
Dr. Upendra Baxi
While
sir.
his contributions to the
While
world
his
of law speaks
contributions
for
to the world of
themselves,
law speaks for themselves,
still I feel blessed
still
to
I
have the
feel blessed to
opportunity
have the
to extend
opportunity
a few
to
words
extend
of
a few
welcome.
words of welcome.
So, on behalf
So,
of
on
our
behalf
Dean,
of
Professor
our
Dr.
Dean,
Namita
Professor
Joshi
Dr.
ma'am, and
Namita Joshi ma'am, and
Associate Dean, Professor
Associate
Dr.
Dean,
Anirudh
Professor
sir,
Dr.
I extend a
Anirudh
very
sir,
warm
I
welcome to you,
extend
sir.
a very warm welcome to you, sir.
Professor Dr. Upendra Bakshi
Professor
sir is
Dr.
among the
Upendra Bakshi
most
sir is
distinguished
among the
legal
most
minds, and
distinguished
his
legal minds,
remarkable
and
academic journey
his
began
remarkable
at
academic
Gujarat
journey
University
at
and the
Gujarat
University of
University
Bombay,
and the
and
University
later
of Bombay,
took him
and
to the
later
University
took
of
him to
California,
the
Berkeley,
University of
where he
California,
earned
Berkeley,
his
where he
doctorate
earned
in
his
juristic
doctorate
sciences.
in juristic sciences.
Over the decades, Sir has
Over the
adorned
decades,
several
Sir has
prestigious
adorned
positions
several
like Dean
prestigious
of the
positions
Faculty of
like
Law,
Dean of
University
the
of
Faculty
Delhi,
of Law,
Vice
University of
Chancellor
Delhi,
of
Vice
Delhi
Chancellor
University,
of
and
Delhi
the University
University,
of South
and
Gujarat,
the University of South
Honorary
Gujarat,
Director of the Indian
Honorary
Law
Director
Institute,
of the
and
Indian Law
President
Institute,
of
and
the Indian
President
Society
of
of
the Indian
International Law,
Society of
and among
International
many
Law,
others.
and among many
He
others.
taught at leading
He has taught
institutions
at leading
worldwide,
institutions
including
worldwide,
University of
including
Sydney,
the University
Duke
of
University,
Sydney, Duke
NYU,
University,
University of
NYU,
Toronto,
University
the
of
Jindal
Toronto,
Global Law
and
School,
the Jindal
to name
Global
just
Law
a few.
School, to name just a
His
few.
scholarship spans
His
diverse
scholarship
areas
spans
such as
diverse areas such
comparative
as
constitutionalism,
comparative
human
constitutionalism,
rights, legal
human
theory,
rights,
law and
legal theory,
sciences.
law and sciences.
Sir has also delivered
Sir
the
has also
prestigious
delivered
Hague
the
lectures
prestigious
in
Hague
private
lectures
international
in private
law and
international law
continues to
and
serve on the
continues to serve
editorial boards
on the
of
editorial
leading
board of
international law
leading
journals.
international law journals.
Sir is currently
Sir is
serving as the
currently serving
Emeritus
as
Professor
the
of Law
Emeritus
at both
Professor of
the
Law
University of
at both
Warwick
the
and
University of
the
Warwick
University of
and
Delhi.
the University of
Sir,
Delhi.
your presence today
Sir,
is
your
not
presence
just an
today
honor
is
but
not
an
just an
inspiration
honor
for
but
all of
an
us.
inspiration for
We
all
are
of us.
deeply
We
privileged
are
to have
deeply
you here,
privileged to
and we
have
are
you
looking
here,
forward
and
to
we are
valuable
looking forward
insights
to
which
valuable
will
insights which
undoubtedly
will
enrich our
undoubtedly
knowledge and
enrich our
perspectives.
knowledge and
With
perspectives.
these words, I
With
once
these
again
words, I once again
heartfelt
extend a
welcome
heartfelt
Professor
welcome
Dr.
to
Upendra
Professor Dr.
sir.
Upendra Bakshi, sir.
Hello.
Yes, sir.
Yes, sir.
I can't hear you. I can't see anybody. That's how life is. Thank you very much for your kind words of welcome and doing the humanly impossible of um, breaking the old Indian tradition with consistent saying that I don't need to introduce the speaker who is very distinguished. But then one goes on and on, leaving very little time to the speaker. Very departure, refreshing departure. Well, I divide human beings into two kinds or two species. One, those who are distinguished and those who are distinguishable and not distinguished. I'm very glad at last promise that I gave to Dr. Namita Joshi. For a long time, while she was at Chandigarh, first physically and legit, and then, but then not to be, Dr. Joshi. I'm happy though that I can redeem it now. In many ways, Chandigarh is lost, if I may say so, is Delhi's gain. And I'm glad to meet all the colleagues and distinguished participants in Faculty Development Program, FDP, to meet you here today. I'm sure that under Dr. Noida, the NIU and SLLA, the last two letters standing for legal affairs, will prosper and thrive under stewardship of the school. I really like the word affair. I was awarded the Padma Shri, for example, for my, I shall call it a Darius, so Darius, yes, with public affairs, affair. I like the word affair. And I think I can clearly use it today by saying all law is an affair with justice. I like affairs. Affairs doesn't have only one meaning that normally we give to it. Affair means something deeper and more. I just gave a webinar at the North Cap University in Delhi on law desires and desire for law. I think it's available now, hopefully in the YouTube or somewhere. And I think desire for justice is the affair of law. And affair is a very beautiful word, albeit a bit romantic word, but law as affair is rarely thought of or studied. And I'm very glad to have this occasion to be with you all and to talk about AI law's affair with justice, modifying it slightly. Now, coming to the precedents, as laws normally do, my knowledge of my concern with AI goes back to year 2000. In human rights, or Human Rights was published by Oxford University Press. I think in chapter 6 of that book, I did address in some detail, I think, the idea of digitalization and human rights, how human rights affect digitalization, and how digitalization affects human rights. So I think all teachers in the school here who teach human rights or international law must ponder on affairs, habits of heart that guide the development of law, the principles that are basic to human civilization. But first of all, I must confess several biases, which are biases against what is called AI. In several of my talks on AI, which are purely negative, pessimistic, and first of all, at the NLUD webinar a year ago on AI and the law, I started by referring intelligence is not a new word at all. It was used, first of all, by Chief Justice of England, called Chief Justice Cook in the beginning of 16th century, with a cane balance. I think it was James I. And James I decided in the beginning of 16th century actually adjudicated the matter was appealed before the Chief Justice of England. And quite rightly, Cook said, addressing the monarch, that you have infinite wisdom, divine grace, and divine justice in your hands. And in your wisdom, you can do almost anything. But one thing you cannot do, and I'm paraphrasing Cook, one thing you may not do is to decide disputes. Because this requires deep study of law, of precedents, and generally legal knowledge, which is not necessarily encompassed um, in the monarchical wisdom or wisdom of parliament. It comes after long learning of law and precedent, what we call legal knowledge. And therefore it said, and these are the words I want you to remember, please. Words of Lord Cook were, the law has an artificial reason of its own. That was said in 16th century by Lord Cook. And today we are discussing in 2025 AI, which is nothing but artificial reason of this thing. So law and artificial reason go together. Law is often called an artifact of reason. Artifact of reason. What does that mean? That is, law has a peculiar logic of its own, peculiar way of reasoning things of its own. And that's the important part of it. And therefore, I was interested in this affair long time. And I addressed it in detail, I think, in chapter 6 on digitalization and human rights of my book, which I mentioned, Post-Human Ego and Human Rights. First of all, let me confess my bias against AI, what is called AI. I don't know what is AI, but people distinguish between general intelligence and particular intelligence and all that. I won't go into that. The word has come to stay, but needs examination. Whatever we may want to mean by AI, we at least know that AI delivers the data fast and also loose, very often loose, but fast. I'll come to loose part of it later. I am against AI, I am biased against AI because I come from the study of laws of war, what is called international humanitarian law. And modern military defense production and defense operation everywhere throughout the globe. Modern international military law, military affairs, warlike deploy in war and aggression short of war, armed conflicts, inhumane practices, or digital weapons with precision, whether it's Iron Dome or now Golden Dome that Mr. Trump is talking about. He wants everything golden, of course. Iron Dome, Israel boasts of, which is a series of online programs. It intercepts any missile that comes into Israeli territory. And it is very precision sharp. It destroys the missile. It is also used against human beings. And drones, for example, have transformed the world military production and use. What Julius Stone called, in relation to nuclear weaponry, you listed a marvelous phrase called depersonalization of warfare. Depersonalization had reached its highest point in the drone warfare. The computer makes all the program, the algorithm makes all the decisions as it goes along. And it has affected very much the status of international humanitarian law. I hope you teach it at your school. I believe nothing is more important than modern warfare to study and to law. And IHL has virtually, international humanitarian law has virtually vanished from the scene. I give one example. In the unconscious irony, the U.S. Defense Department, which has now been renamed as Department of War by Mr. Trump. But in unconscious irony, U.S. Defense Department, that is then war, named Lethal Automatic Weapons System. It took the first letters of the 4 words, Lethal Automatic Weapons System, and abbreviated them, believe you me, as LAWS, LAWS. Please remember, as things that have to do with law, in fact, which flouts the law, is deliciously, in a delicious irony, named as law. And Dr. Joshi should remember, Chandigarh has a only distinction, the whole world, of having a faculty of laws. It's not faculty of law. It is faculty of laws. So international human rights, lethal atomic weapons are considered as laws, abbreviated as laws. A great irony there. Now, I have a number of reservations about use of precision target automated bombing, into which I would not go, and which arise out of trying to bring human into warfare. It's not machines. Mechanization means mechanization of international. And unless programmed, they can do great algorithmic harm. Concept of algorithmic harm is harm caused to civilians in case of warfare or armed conflict. This harm is called necessary harm or collateral injury. Like when you hit somebody, certain civilians also get killed. It's collateral injury. It's called mortal. There is now a great movement, those who study international law will know it, to bring human back into international humanitarian law instead of machine. So that's one caution I am against. I come from the understanding of weapon systems that have developed through the use of AI. How do we regulate them? How does legal education do this? It's very important, legal research. I'm not saying there should be no legitimate defense production and that there should be no legitimate armed defense. There are year-long conventions from Geneva and Hague Conventions that are called of international humanitarian law, IHL, which are completely ignored and they should not be ignored. That's all I'm saying. But that's one. The second thing is, water usage by AI itself on the research program, you will find that data centers produce 1,200 liters of water globally by 2030. And 2030 is 5 years away. It is declared to be the time when freshwater supply of the entire world runs out by the International Water Commission. So one looks to AI, naturally, to find a solution. Not so naturally, but most people do actually. And what do they find? They find that the prediction of World Water Commission that there will be no fresh water on the face of the earth by 2030, 5% will come true. AI uses an enormous amount of fresh water for cooling towers. And it's a source of water loss. I will not go on and on this, but I'll give an example. Each query to an AI chatbot, such as ChatGPT, is estimated to consume consisting of 500 millimeters of energy due to the cooling demand. Training a single large language model, LLM, like ChatGPT 3, and now in version 4, has been estimated to require 700,000 liters of water. 700,000 liters of fresh water through direct evaporation. This water is drawn from groundwater and much of it lost through evaporation in the atmosphere. And there's complete lack of transparency on how much water is evaporated by the companies AI. There's some concern by Google about sustainable development. Everybody likes sustainable development, and so does Google. But what is sustainable for industry is never sustainable enough for the planet as a whole. So sustainable is trade-related industrial friendly standard. Sustainability in terms of peace, planet, and prosperity. See peace of the Paris Declaration against global warming and climate change. The CPs are rarely to be found in literature on corporate social responsibility. I will be proved wrong. Kindly contradict me if you have a problem with that, and I'll turn correct it. Happy. So essentially, I'm not saying that AI does not have a role, but at whose cost? And at what cost? What cost? And for how long this cost? The three questions that we ask. What is the cost of doing AI program? And AI is a bundle of programs. I don't believe in the general AI, discrete general AI, and particular AI, and I don't delay you with this. But I think there's a problem. There's no doubt that AI does work with speed and works with complex concepts and complex sets of data in a remarkable time, real time. So that you go to a search engine, you go to a program driven by AI, and you find astonishing speed with which answers. Now the question this raises for legal education and legal research, legal studies, and justice are major. Is speed a good thing always? That's question one. Second, how does speed relate to justice? The second concern. Thirdly, what costs do we incur in achieving speed economy, speed development, smart cities, smart this, smart that? These are smart days. Everything is smart. What cost is it? What human rights cost do we pay in achieving this smartness? I think this is something I must leave to you. But certainly one recognizes that the speedy computation of AI has some good part. I heard long time ago at NLUD, a colleague from faculty Unang, the faculty of law at Malaysia in Kuala Lumpur, take a whole hour on what he researched into gaming and how participative reading of law course between the teacher and the class can be mind-bogglingly fascinated by the course of computer games. As far as I understand, it was a absolutely marvelous idea. In India, you have a similar thing. I think it's called a program called Time to Justice. I'm sure time to letters to justice, time to justice. Now, naturally, time to justice is a great legal tool, which I've not used, I must say, but I know about it. It has tremendous use in case analysis, research into case law and attributes arguments and judgments very quickly. It is great automated platform for legal advice and aid. It's a great device for summarizing various complex contracts and identifying associated statutes. And it is great in predictive outcomes, which are often estimated with great accuracy. So they predict, the algorithms predict many things, many outcomes in many fields, and they come out to be true. So again, I'm not saying that all AI is wrong. I'm saying all AI incurs certain future costs in terms of global warming, in terms of freshwater resources, in terms of many things I've said earlier, in terms of justice, in terms of rights. And these costs also have to be, who pays for these costs? How these costs are to be paid? Say, by future generation. Have we developed, apart from a solitary judgment of the Supreme Court in Goa Foundation case, the idea of international justice? The Supreme Court developed for the first time this idea for India and asked for a trust to be set up for future generations. Does AI help us understand future generations? Does it helping us understand how future generations can be studied and explored? Did it predict or otherwise happening in Colombo and Nepal in the name of Generation Z? These are valid questions and should encourage us who are thinking about law and justice and role of role of AI. Similarly, e-discovery. In other words, Time to Justice is a website which has several uses. It uses um, web platforms which analyze legal documents, languages, and fosters analytical skills. It also provides you virtual legal assistance, which you can use in teaching and learning law. No question. It provides for interactive legal learning, several platforms engaging several dynamic platforms, gamified other learning programs, provide a great educational experience. And Time to Justice also saves money because there was a engineering company called what was called La Baba engineering group of company turned to Time to Justice and leverage its profits by cutting 99% and saving 1.25 lakhs in 2 seconds. So you can use this free money as surplus profit. Can you hear me?
Yes, sir. Yes.
Yeah. You can do a surplus profit in record time, in the real time. So question is, AI has corporate uses. Do we study them? That's the question. How do we study them? How do corporations make super profits? Michel Foucault, the great French thinker, had a very nice phrase which I still remember, a nice set of phrases. He talked about hyper profits, and infra power. Infra power. Power is it goes inside the veins. The making of the world for you. So infra profit, infra power. That is intravenous power. Intravenous power is and hyper profit. And so this is very important. Other two ideas and then stop because I do want a discussion. But I think in terms of data analysis, in terms of solutions, in terms of insight, in terms of enhancing legal research and legal skills analysis, this is a useful tool. One cannot deny. What's and all, whatever be the problems otherwise with AI. And how by using these tools you can develop legal aid programs, legal justice programs. But there are certain shortcomings which I will note quickly, but there's not much time. I passed by a lot of my notes. But I'll say two things. That being in law schools, at least Indian law schools, are not quite familiar with literature on AI. I'm very sorry to have to say this. We are familiar with checkbox and ChatGPT and all that. And people use it. I know I don't use it. Worried about computer and a law scholar. And his name was England. And Susskind was very worried about the future. Books about our legal profession. We should read this book. Our students read this book. And Susskind basic conclusion was the lawyers. He thought lawyers would disappear, like other professions, days and disappear as age advances. Not merely they will transform, they will transform. Place for services and goods. They will have to transform themselves. I don't know of a single book which considers the careful effect of legal profession and on legal profession by the AI advancement. We have here and there tidbits that titillate us. But we don't have a real thing. At least I'd be glad to be wrong. This is my feeling. So that is one. I think we must study Susskind carefully because he recently gave up, put his hands up in 2025. He wrote a blog post, I think. What about down my spine? What will shiver due to? The fourth edition of ChatGPT produced an article by Professor Susskind. What was the article? On the future of legal profession, the marketplace. I said, all my life I work hard with machine learning has totally replaced me. It's a so beautiful article that I could not have written. It sent down a shiver down my spine, he said. So computer is gradually taking over human functions. It's a thing or a bad thing. UNESCO has talked about this particular a small booklet called The Ethics of AI, which you might have read or you must read. But how do we develop ethics in the use of AI? It's a very major favorite lesson. The computer Kurzw, A Kurzweil is a cyber, say. Not a single of his predictions formed as laws of the future has come wrong. It's a remarkable record. Remarkable indeed. How does any human being turn out to be a predictor, prophet, what you learn from? I have written two books which I recommend very strongly. This singularity, it's called it's called study is there. And 2000 second year close. First because in part his second book says at least I won't be there for sure, but you will be here and your students will be in 2047, the year 2047. Machine learning, machine intelligence will replace biological intelligence. The concept of learning linked with biological intelligence, with epistemocracy, epistocracy, ruled by the elites, by those who know. Everything that we know today, combination learning. And we take the whole different class and this by 2047. The prophecy. The machines will not simply follow algorithms. It is certain rules of operation. You can't help it. You can ignore it. The message will be sent. It is what the receiver does with what he or she gets on the mailbox, on the chat box, is more important. So communication, whether communication takes place, is a central question in studying the old AI. Sending a message is not important. What you do with these messages in your personal life, in your social life matters. So if you think of communication, communication is a planned disturbance in the state of mind, the state of your word. It interferes with your mind. And how far the interference succeeds, how far does the force of communication itself become a factor of global social change, is very important. I think that's enough for the time being. I might only add a word for those who are interested in philosophy of AI, that it is better to think of artificial intelligence, better to think, bans the word artificial intelligence, better to replace it with artificial communication. And that involves, as far as legal studies are concerned, at least one thing, so we don't have time, one thing at least, and a major thing. It involves the distinction between law on the one hand and regulation on the other. Now, this distinction, you may not know it, discussed widely by some people in literature on AI, but they don't know it. Who originated distinction? The distinction was inaugurated by a man who was killed by Vyshensky in Soviet Union in the revolutionary period. Why Vyshensky killed Pashukan is killed. Pashukan was a young jurist, the only jurist who was killed by the state at the age of 30. Why was he killed? Assassinated by regime, revolutionary regime. Because he wrote, there cannot be any such thing as bourgeois law or socialist law. It's a mistake. You're doing analysis, you're doing nothing, no politics. You're doing analysis. Poor chap. And you're shot dead. The only I know in law is Pashukanis. There might be others who protest for human rights and all that. I respect all of them. You must study legal martyrs, but no law school in India. That's what I know. Study legal martyrdom. They study AI. It's more fashionable, more chic. Good luck to you. But I think Pashukanis, who was killed by Vyshensky for his fault in writing a book distinguishing between law and regulation. And by law, he meant political law. Law is always made by legislature. Legislatures are elected representatives. The great philosopher, legal philosopher, a long time ago, said, what is law? Accepting treaties of peace, ad hoc treaties of peace made in the legislative assembly. A beautiful idea. Laws never settle disputes or problems, but they for the time being adjust them one way or the other. The problem remains. The problem of rape remains. The problem of dowry burning remains the same. Only the new Nyaya Sanhitas begin, penal code begins with the first chapter on women. That's a very welcome beginning. Every day we hear of dowry death and murder and rape. The position of women has not changed, but the law has changed. So regulation is different. Regulation is technical law. It is not political law. By regulation, Pashukan is meant for this shortness of time. For example, rule of the road They're not political. They're found conservative. Diving is left or right doesn't make any difference politically. Diving is diving, or swimming is swimming. Or whether you play this game with Pakistan or some other enemy country or not. It's a matter of regulation. Regulation is technical. It's based on convenience. It's not based on ideology. The law is made on ideology. Law thrives on ideological politics. Democracy thrives on ideological politics. Rule of law thrives on ideological politics on either side, on every side. So really this is a distinction between law and regulation. Really a very, very important point. AI over which it had no jurisdiction. And as far as far as I know, Google did not comply with the request. It asked simple question, what a Google Print's function was. How was it trained? What does it do? The court is still deciding the issue, but there was a big question of privacy, enforcing privacy. It's a public virtue against privatization of information. Here I stop positively. Now I have a problem. I'm not very good to reveal a secret to get into the chat box. So please appear on the scene. I don't see you at all. Appear on the scene and raise your questions, what you have, or go through the compare and tell me what the question or comment is. Thank you for the time being. For my presentation will take a longer time than it should. I'm sorry for that. But I think you got some perspective. That I've shared some perspective with you. Thank you again. Now, any time for comment.
Thank you so much, sir. Now I would like to invite the participants if they have any question they can ask.
Already a hand ultimately, yes. Yeah. Any question, any comment?
So I'm getting very positive feedbacks, but I think you have well resolved all the queries. So everyone is just having, everyone's feeling very blessed with your session. So I don't think they have any questions, like, as you have already resolved all their queries. Thank you so much, sir, for such an engaging.
Sorry to
Yes, sir.
interrupt you, but I've totally failed if there are no comments or questions.
Uh,
Now, there is one by Malvika Sharma who raised a hand, but I don't know what to do with it. Yes, please. Please.
Malvika Sharma.
yes, Malvika, you can ask your question.
Yeah.
You can read the comments even though, Manish.
Yeah.
I think Malvika left.
She was trying to ask something, but I guess she is having some network issue.
No.
So with your permission, can we proceed further concluding this session, if you allow us?
Yeah, as you like.
Okay, so then thank you so much, sir, for such an engaging and
Pooja,
insightful session.
Pooja wants to
I'm
ask
sure
something.
Pooja, okay, Pooja ma'am, if you want to ask something, you can ask.
Good morning, sir.
Good morning.
Sir, thank you for such an insightful lecture. It was very interesting. My question is, in the age of deepfakes, where there is digital creativity, how do you draw a line between satire, parody, and legal liability?
That's very good. I fortunately, otherwise, I don't have to do a line myself. But I think the relationship between freedom of expression and state security has always been a problem since independence. And the Supreme Court and the courts in general have elaborated various conceptions of legal order and disorder. The aesthetic theory has a very good word called chaos moss. Chaos moss is not moss, chaos moss, CHAMOS, which stands for order disorder. And there is order in art, beauty. One way of defining beauty is to speak of chaos moss. There's some degree of chaos, but also there's some degree of numbness. I think in satire, in sketch, and sitcoms, there are various forms of expression. And I think that wherever there is legal majoritarianism in the world, and wherever there is intolerance of dissent, problems do arise. And these problems are not fully addressed by judicial discourse, save in a few cases. What is responsible speech, and what is, and the Supreme Court has provided some tolerable answers, tolerable, not vulnerable, answers, but not in all cases. And what they have said, of course, is that the word incitement has to be carefully and reasonably interpreted. Intolerance of opinions of others is not constitutionally permissible. That's the norm. The practice always contradicts the norm. The norm. I give up the norm. Thank you. And I think this is where the problem lies. In every generation, we have to wage the battle afresh between freedom of speech and public order. For example, the Supreme Court's current stance is interesting. When they say when investigations take too long to fructify, we have a duty, that the court has a duty to even declare criminal defamation unconstitutional. The matter is now under consideration of the highest court. Any other comments or questions?
Thank you, sir.
Thank you.
Thank you, sir.
Thank you.
So there is one more question by Prashant Kumar.
Good afternoon, everyone. Sir, my question is, should the training of AI models be allowed freely to use copyright holders' work, or be restricted to honor the right of copyright holders? Like many cases are going on these days in foreign as well as in our country, whether it should be allowed as a fair use, or there should be a restrictions on the use of their copyrighted work to train AI models.
Thank you. That's a very interesting question. We had a judge called Justice Enlow. And Justice Enlow gave a model decision in the case of xeroxing whole books by Delhi University, Keogh. And the Keogh was supposed to violate the copyright of publishers, and some famous publishers in India filed a copyright suit. But Justice Enlow, as I was privileged to tell him later, virtually ended the law by recourse, as you know, to the idea of fair use. And he said it was fair use to xerox all books, whole books, for the purpose of training and research. And no copyright can be said to be violated. So it's not only AI, it is the expansion of the doctrine of fair use that one has to take into account. But you are right. on the question of what's being commodified and presented by check boxes. It's a purely mechanical operation. The data is a aggregation of bots, and then the machine analyzes and puts them together in its own way. So technically the question now becomes not partly becomes one of copyright right versus bots, arrangement of bots. I don't know how the courts will be able to come out of this problem. But arrangement of bots, analysis, the aggregation, the reformulation by ChatGPT, for example, can be shown to be original work under the law of copyright. Just as telephone directories or racing catalogs are all copyright. Train and aircraft arrival and departure, etc., can be copyrighted and are copyrighted. Similarly, an arrangement of bots which results in new literary work can, instead of being indicted for violation, be said to represent a new literary work. And remember, Justice Anandamurthy or some Anandamurthy Iyengar in Madras in 1955, he wrote in his judgment, Madras High Court, a very nice sentence. He says the copyright law does not protect originality, but originality, and I quote him, at its most vanishing point, unquote. So the way in which originality is defined, as you no doubt know, is not originality in the sense outside the law. Defines it, imagines it. But I would say extensive use of fair use law might probably solve this problem. I don't know how the courts will decide, particularly the American courts, that the New York Times case, which is awaiting its judgment still. But if you take a minimalist idea of copyright law, an idea of protection of originality at its most vanishing point, then perhaps I don't see much of a problem. So maybe it's not what you wanted to hear.
Thank you, sir. Thank you so much, sir.
Thank you so much, sir, for such an engaging and insightful sessions. We all are feeling very blessed and honored to listen to you. Now, I would like to invite our Dean, Professor Dr. Namita Joshi, ma'am, to present, to say a few words in your honor.
Thank you.
Thank you, Manish, sir. Am I audible?
Yes, ma'am.
Yes, it's not visible.
Yeah, thank you, sir. I have many things to say, sir, actually, because everyone can be relate with it. That's today's session was not only the session, it was a sort of a blessing for all of us who has attended this session, either directly via link or directly or with the YouTube or where they are joining. But it's really a kind of blessing for all of us. And it is not just, sir, I must say, sir, you are the wisdom of living institution. So we are not just experience the direct learning from you, but it was the kind of living institution that we are hearing for all these sessions. And apart from this all the things, I must say that if I talk about your work, either it's your work with uh, sir, sir, actually, Aniruddha sir wants to say something. Yes, sir? Huh?
Maya.
Okay. Okay. Sorry, sir. I mean, my dean associate is so crazy, and he's saying that he would love to speak something. So that's why he was here. So, sir, I must say that either if you talk about your work in the constitutional law, or it's your fearless advocacy for the marginalized things, or if you talk about the humanistic approach that you have, either whatever you have did, this scholarships can be harmonized with the moral courage that you show in your activities and in your every approaches you have did it. If today's session was not merely an academic engagement with all of us, but it was an experience that will resonate deeply with each participant that who has attended this session today. Your word will be really echoes with the wisdoms, and your ideas will really challenge and inspire to all of us. And your humility, if we talk about the everything, whatever we discuss here and whatever you have said to us, it will remain with us to for all the true meanings and with the greatness. So we are really very thankful for your lifelong commitment and for shaping the young minds. So wherever I spread this message that you are joining us, everyone was giving the very good comments, and everyone was so feel so touched. You mentors people uh, very with a very kind heart, and you standing for the ethical foundations. So on behalf of each and every participant and the faculty members and the organizing committee and from the Noida International University, so we extend our best gratitude to you, sir, for this session. And with profound respect, sir, I would like to give thanks to you, sir. Thank you very much, sir.
Thank you, ma'am. Now I would like to invite
Thank you.
Dr. Devendra Sir, Associate Professor, School of Law and Legal Affairs, Noida International University, to deliver the vote of thanks.
Thank you, Manish. Good afternoon, everyone. Sir, dignitaries, distinguished faculty members, colleagues, and dear participants. On behalf of the School of Law and Legal Affairs, Noida International University, I have the honor to propose a vote of thanks to our distinguished resource person, respected Professor Dr. Upendra Baxi, sir. It is indeed a singular honor for me to extend the vote of thanks at the conclusion of today's remarkable session. On behalf of the organizing committee and all the participants, I express our deepest gratitude to Sir for accepting our invitation and sharing his profound insights with us. Sir, your insightful reflections on the transformative impact of artificial intelligence on justice, research, and legal education have not only broadened our academic horizons, but also inspired us to uh, think more critically about the future of law, technology, and society. Particularly enlightening was your discussion on the effects of the artificial intelligence on human rights, the ethical dilemmas of technological progress, and the hidden cost of innovation, such as the vast consumption of water in running advanced models like ChatGPT, the need for a truly sustainable industry, and the pressing concerns of climate change. So these reflections remind us that the discourse on artificial intelligence must extend beyond efficiency and productivity to include human dignity, equity, and environmental justice. This session will remain an invaluable part of our academic journey. I also extend sincere thanks to our respected Vice Chancellor ma'am, Dean ma'am, Associate Dean sir, faculty colleagues, and the participants for their enthusiastic presence and engagement, which have contributed to making this program a success. Once again, on behalf of everyone present, I place on God our heartfelt appreciation and gratitude to Sir for gracing this program and making it so valuable and impactful. Thank you, sir. Thank you, everyone.
Thank you.
Thank you so much, sir.
Thank you indeed.
Thanks to all the participants. Here we are concluding the session 1. Now we will be connecting back at 10:30 for session number 2. The schedule will be shared very shortly in the group. Thanks to all.